Now recently, the Honorable Supreme Court of India has expressed grave concern and displeasure over central government seeking another adjournment in the case challenging the Tribunal Reforms Act of 2021. Now this highlights and this reignites the ongoing tensions between the judiciary and the government of India over who is able to control the tribunals or over the tribunal control. Now first of all, what are tribunals? What are tribunals meant for? What is the constitutional status of tribunals and who actually control tribunals, and what is the controversy between the central government and the judiciary? All these things we'll be trying to understand in today's session. Hello, my name is Preetpal Singh and you're watching Perspective. Now starting from the basics, the question is, what are tribunals? Now tribunals are judicial or quasi-judicial bodies which are created to handle specific type of cases or specific type of disputes which either requires expertise or requires faster resolution. Now for those cases, a separate quasi-judicial body has been made and that body is known as tribunals. Now tribunal performs number of functions, whether it be adjudicating disputes, whether it be determining the rights between the contesting parties, or making an administrative decision, or reviewing an existing administrative decision, and so forth. So which means a lot of functions are performed by tribunals in our country. Now tribunals is often referred to as the office of the tribunes, that is a Roman official under the monarchy and the republic with the function of protecting the citizen from arbitrary action of the aristocrat magistrates. That is where the word tribunal and the term tribunal is derived from. Now since tribunals are quasi-judicial bodies or judicial bodies, its function is manifold and the need of tribunal is very vital, because tribunals are the ones whose main goal is to reduce the burden on the regular courts. So right now the pendency of cases in various courts, especially the district ones, is a major. Alongside that, there is huge lot of a workload on the courts, because every single day there are tens and thousands of new cases coming on for the district courts, for the high courts, and for the Supreme Court of India, which is why it is very vital to create these separate type of specialized courts, specialized quasi-judicial bodies, in order to reduce the pendency of cases and reduce the workload on the regular existing courts, which is why tribunals are essential, tribunals are vital. Other than that, the second reason is to bring technical expertise. Now normal regular judges, they are aware of the common laws, they are aware of the laws, they are aware of the constitution, they are aware of the legalities, but they are not experts in one specific domain. In order to bring technical expertise for individuals in those technical domains, tribunals are essential, which is why tribunals can provide expertise in matters related to taxation separately, matters related to corporate law separately, matters related to administration separately, and so on and so forth, which is why tribunals are very essential for our polity. Now we need to know the constitutional status of tribunals. One very important thing under this constitutional status is that tribunals were not mentioned in the original Constitution of India, which is why tribunals were formally established through 42nd Constitutional Amendment Act of 1976, which introduced two prominent articles in our constitution, that is Article 323A and Article 323B. Amongst these articles, two set of tribunals were made. Under Article 323A, Parliament is given the right, or it allows the Parliament to create administrative tribunals for public service matters. So here administrative tribunals can be created under Article 323A. Now there is second article, Article 323B. Under this, it allows the Parliament to create specific tribunals, or also the state legislatures, they can also create separate tribunals on the subjects like taxation, like land reforms, and labor. So amongst these three classes, separate tribunals can be made by either the Parliament or the state legislature under Article 323B. But this was in the year 1976. As the year passed by, in the year 2010, Honorable Supreme Court of India widened the jurisdiction under which tribunals can be made, which is why Honorable Supreme Court of India classified and clarified that the tribunals can also be formed on other subjects as well, other than what is mentioned in Article 323A and Article 323B. On other subjects as well, tribunals can be formed, which means the subjects which are mentioned in the 7th schedule of our Indian Constitution. So other subjects which are mentioned in the 7th schedule of our Indian Constitution, on those subjects as well, tribunals can be formed. This was clarified by the Honorable Supreme Court of India in the year 2010. Now, since we know what are tribunals, we know about the constitutional status as well. What we need to now talk about is the problem or the controversy of a judicial independence and the Supreme Court directives. That what is the problem of these things in relation to tribunals? Since Honorable Supreme Court of India has time and again emphasized that tribunals should enjoy and must enjoy the same level of independence from executive as the judiciary enjoys, which is why tribunals would be able to run smoothly if they enjoy same level of independence from the executive as the judiciary is enjoying right right now. This is what Honorable Supreme Court of India wants. And in this independence, what exactly this independence from executive includes, it should be devoid of any executive interference. Second, the composition of tribunals. And third, the tenure of individuals who are working in the tribunal, tenure of the members of the tribunal. In these three categories, independence from executive must be ensured for the tribunals. This is what Supreme Court of India wants. Also, the Supreme Court recommends that the administrative control of the tribunals must be within the law ministry and should not be with the ministries they adjudicate against, and later proposed to form a National Tribunals Commission as well. So, National Tribunals Commission has been proposed by the Supreme Court of India, and these reforms which are given by the Supreme Court has not been implemented by the central government. That is right now the status. So one set of tussle now we are aware of, that Supreme Court of India wants tribunal to be independent from executive control, and executive or legislature is not wanting the same, which is why they have not implemented the reforms suggested by the Supreme Court. That is one set of controversy. There is another set of controversy that is related to Tribunal Reforms Act of 2021. Now this Tribunal Reforms Act of 2021, it has been challenged by Madras Bar Association MBA for allegedly undermining judicial independence, one, and violating the separation of power, the doctrine of separation of power. In these two areas, Madras Bar Association has challenged the Tribunal Reforms Act of 2021. Now, tribunals which are handling specialized cases in areas either like taxation or labor or corporate law or administration has been affected nationwide by the ongoing case. See, if we trace back in time, we'll be seeing the year of 2017 as the year where actual tussle between the central government and the Supreme Court of India started. So in the year 2017, there was Finance Act of 2017 which was passed. Now the whole controversy surrounded this particular act, because this Finance Act of 2017, it gave the government the power to make rules for tribunals. Now this was the act which irritated Supreme Court of India, and in the year 2019, the Supreme Court under Roger Matthew judgment struck down this particular rules and said that they weakened the judicial independence. This was the chronology of events from 2017 to 2019. And the reason of controversy was one, that who would make rules for the working of tribunals, which means who would control the tribunals. Now in the year 2020, this controversy would gain more heat because the central government would introduce tribunal rules of 2020, which again were challenged by the Madras Bar Association, and the Supreme Court suggested key changes. And those changes were, first of all, including 5-year tenure for the tribunal members. First of all, in order to protect their independence and also to attract qualified professionals for the tribunals. That is what Supreme Court of India suggested. But central government defied the orders. And central government, however, on 1st of April 2021, central government passed an ordinance seeking a 4-year tenure or a 4-year term and a minimum age of 50 years for tribunal appointments, which again irked the Supreme Court of India, because Supreme Court of India has very clearly suggested 5 years term for judicial independence, and the next year, the very next year, central government comes up with an ordinance for 4 years of tenure for the tribunal members. But the controversy again would strike back when few months after this, on July 2021, Supreme Court of India will again strike down these rules and these provisions as arbitrary and against the principle of separation of powers. Citing these two things, Supreme Court of India will strike down these provisions under the ordinance which was passed on April of 2021. But again, Parliament had a very defiant response to it. So again, the tussle between executive and judiciary continued, because once the judiciary strike down these provisions under the ordinance, after few months, a month later actually, Parliament passed Tribunal Reforms Act of 2021. Now a specific act by the Parliament was passed, again challenging the guidelines given by the Supreme Court and violating those guidelines. Now in this Tribunal Reforms Act of 2021, they reenacted the same struck down provisions. The same provisions which were struck down a month back came again back to the fold when Tribunal Reforms Act of 2021 came. And this particular move by the legislature again reignited the controversy and the clash between judiciary and executive of our country, with the critics calling it a direct challenge to the judicial authority. And this is where Madras Bar Association argued against the act. And Madras Bar Association simply said that the provisions of the act were also involved in the ordinance which was struck down by the Honorable Supreme Court of India, which means that the same set of provisions should not be in the act, and by putting those provisions in the act, Honorable Legislature is having a defiant attitude against the Supreme Court. And by reenacting the same provisions without addressing the legal flaws identified earlier. The petitioners, that is the Madras Bar Association, claimed that the Parliament attempted to override a judicial verdict, and they used one word, that this amounts to legislative overruling and weakening of judicial autonomy. Now, the Madras Bar Association argued one more thing, that this 4-year tenure for the tribunal members would make them vulnerable to government pressure and will make them succumb to the government's demands, and also they might act cautiously in order to seek reappointment, which is why they won't be able to act independently of the executive. That is what Madras Bar Association highlighted. Alongside that, it also suggested that having the minimum age of 50 years, it excludes the younger, capable lawyers, even those individuals who can become High Court judges at a younger age. It excludes all those people, and it excludes the talent below the age of 50, which is again arbitrary and uncalled off. Now, till now we have discussed about the controversy, the clash between the judiciary and executive, and what has been the response of Madras Bar Association, what has been the response of the Supreme Court. But now we need to understand it from the perspective of the government as well, and why is government coming up with the rule, and what is the stance of the government. See, the union government has defended these provisions and said that the age limit, which is minimum 50, it ensures credibility, it ensures experience in the tribunals, and a 4-year term for the reappointment offers enough job security. That is what central government have to say. Also, they argued that the act, that is the Tribunal Act of 2021, which was passed by the Parliament, it basically reflects a policy decision within the Parliament's authority, which means it is within the Parliament's authority to come up with such a decision, and that by striking these rules down, the Supreme Court would be overstepping its jurisdiction and would be overstepping on its powers and would violate the principle of separation of power. That is the stance of the central government or the union government, that these principles have been passed legally by the Parliament of India and shouldn't be struck down by the judiciary, and if they are struck down by the judiciary, it would definitely lead to violation of separation of powers. Now we are able to understand the complete set of controversy and complete set of clashes, and by knowing this, now we understand that where Supreme Court of India and the union government stands on this particular issue. Now, leaving these issues behind, what we need to see actually is what is the actual impact of this particular clash on the tribunals exactly, and on the vacancies which are there in the tribunals. The ongoing standoff for the ongoing clash, it has caused serious delays in filling up of vacancies across several key tribunals. You will see in many of the tribunals, even 80% of the members' seats are vacant till now. As of December 2022, the latest data which is available, the government data shows that first in the National Company Law Tribunal, NCLT, which is again important tribunal, 24 vacancies are there out of 32 total posts, which is again massive, huge vacancies. In the Armed Forces Tribunal, there are again 24 vacancies out of 34 posts of the members. Again, massive vacancy in Armed Forces Tribunal as well. In Income Tax Appellate Tribunal, there are 18 vacancies of the 63 judicial posts which are vacant, or 63 tribunal posts which are vacant. In the Railway Claims Tribunal, both vice chairmen's posts are vacant, alongside 16 positions vacant out of 20 judicial posts in this Railway Claims Tribunal. And in Labours and Industrial Tribunal, only there are 13 presiding officers in place against the 22 sanctioned by the government sanctioned posts. So which means in all these tribunals, we see at least 50% vacancies, and in some even more than that, even 70 to 80% vacancies in the members of the tribunal, which means that the tribunals are not having full capacity to operate because there are no members of the tribunal, and because they are not having many capacity to operate, definitely it will lead to pendency of cases which would linger on for many years. And if these cases are not solved, at the earliest, it will not only lead to delay in justice, it will lead to denial in justice as well. Supreme Court of India, noting this, have observed that this particular thing has led to several delays and has made several of the tribunals virtually defunct, undermining the very purpose of providing speedy and specialized justice, which was the actual purpose why tribunals were made. But it has undermined the actual purpose itself and has led to justice being underserved, undermined, and also the tribunals becoming virtually defunct. So the need of the hour at this point in time is to ensure that the tussle and the clash between central government and the judiciary is solved at the earliest. There needs to be separate negotiations between the judiciary and executive informally in order to solve this particular issue, rather than legally lingering it forward, because it will only be a loss of our own country if this tussle continues. Which is why this tussle should be solved by both the parties at the earliest. Both the parties should come forward with a mature mind, should try to solve this tussle and ensure that tribunals are the beacon of efficiency, and tribunals, they try to solve the purpose which they were meant for, and they try to stand to the purpose which they were meant for. That is providing faster, speedy and expertise justice. I hope you gained a new perspective from the session. Do let me know what are your views surrounding pendency of cases in tribunals and malfunctioning of tribunals in our country. All the very best and have a beautiful day. Thank you.